Good afternoon, everyone, and welcome to the still August edition of the Global Environmental Law Centre's monthly webinar. Thank you for joining us today. Today, I am really excited to introduce our speaker from WITS, but before I do that, just some housekeeping as usual. Can I ask that everyone keeps their cameras off until the end, and questions can also be, or we'll make time for questions at the end of the presentation. There will be about 20 minutes for questions. If you have questions in the meantime, feel free to write it down in the chat box or the Q&A. Otherwise, you can just raise your hand and I will facilitate the Q&A afterwards. But now that that is out of the way, I am very excited to introduce to you our speaker today, Professor Tracy-Lynn Field. She is at the WITS School of Law, and she'll be speaking today about actually a publication that she's submitting in the next week or so. The topic is Transformation, Environment and Water, Evaluating the Constitutional Court's Interpretive Approach in its leading water law cases. Professor Tracy-Lynn Field has 20 years research and teaching experience in the fields of natural resource and environmental law, with a current interest in water and energy and justice. She has published in national and international peer-reviewed academic journals, as well as popular media, and has successfully supervised more than 30 LLM and PhD students. Her current and past research and consulting engagements have involved work for the South African Human Rights Commission, the Fowle Foundation, the Water Research Commission, amongst others. And she currently holds the Claude Leon Chair in Earth Justice and Stewardship at WITS University. Professor Field, thank you so much for joining us today. I'm going to give over to you, and you are more than welcome to share your screen.
Thank you so much, Angela. It's a real pleasure to be here today and to thank you everyone for making the time to listen to me today and my thoughts around transformative constitutionalism, transformative environmental constitutionalism, and water. So I just want to also thank my partners also here who assisted me with the presentation last night. Thank you, Linda, you're amazing. And as Angela said, this presentation is based on a paper that I've been working on for the past about 2 months, and thinking a lot about how transformative constitutionalism, and Melody Murcott, who I just see has joined a theory of transformative environmental constitutionalism, how that lands when you look at the Constitutional Court's leading water law cases. So I'm just going to share my screen. Can you all see my screen?
Yes, it's visible, thanks.
Okay, I'm just going to wait for it to go to presentation mode. Cool. Okay, so what I essentially, in the paper, what I essentially wanted to do was to look at 3 cases, and the cases are the very well-known Mazibuko case, then the Sembcorp Siza case, and then the 3rd case decided this year, which was on water rights, Lotter NO. And when I started looking at these cases and thinking through the theme of the special issue, which is really how transformative constitutionalism relates to sustainability, I thought for myself, how do I, as an evaluator of these cases, how do I see whether there is a transformative approach? When we ask our adjudicators to adopt a transformative approach, what are we really asking for? And so I really wanted to kind of go back. I wanted to go back to Carl Clare and go beyond the sort of oft-quoted citation that transformative constitutionalism, and you all know it, it's been cited so many times, transformative constitutionalism is a long-term project of constitutional enactment, interpretation, and enforcement aimed at transforming a country's political and social institutions and power relationships in a democratic, participatory, and egalitarian direction. And I thought it was important to go back to Clare to kind of distill what he meant by a transformative approach, look at how that's changed over the years, and then look at Melanie's work on transformative environmental constitutionalism, and then go to the cases. So having done that, I was able to see a lot of stuff in the cases. I can analyze these cases from a variety of different themes. I'm only going to speak on 3 of those themes today because of reasons of time. And I'm going to look at how the courts grappled with inequality and how they grappled with water as a commodity and the implications of their judgments for thinking of working towards this place of substantive equality and then treating water as a commodity. And then I'm going to say a little bit about transformative adjudication. I'm not going to say anything about what I feel is also a very important theme, which is how the courts kind of positions itself in a system of governance. In doing this work, I came across Sandra Liebenberg and Catherine Young's work on democratic experimentalism, which I found very exciting. And I could immediately see how that related to other work I've done on resilience. But I'm not going to speak on that theme. But maybe there'll be space in it for the paper. Otherwise, I will do a separate paper on it. So essentially, that's what I'm going to talk about today. I'm going to just dwell a little bit on what we mean when we talk about a transformative approach, introduce the cases, and then evaluate them according to those 3 themes. So it's quite du jour at the moment to talk about a just transition in everything because of the provenance of the just energy transition. We now start talking about a just nature transition. And then one is tempted to say, okay, well, there's also a just water transition. I'm hesitant to do that because unlike energy, where you have a very clear shift in the carrier from centralized fossil fuel-based resources to decentralized sources of energy based on renewable energy, you don't see that same shift in the actual technology of delivering potable water or delivering adequate sanitation, although that's another story about technological options there. But you really don't see that same kind of radical shift in the technology yet. So rather than talking about a just water transition, I just wanted to spend a moment thinking through, what if we have to talk about not looking at the theory, what is our transformative vision for water and what is our transformative vision for water in South Africa? And so that does entail a shift from a current undesirable state to a more desirable state. And if we had to break down that undesirable state, it has many facets. So the starting point is the unequal access to potable water. In 1996, this was a legacy of 12 million people that had no access to potable water. That figure has substantially dropped now. The latest statistics are around 89%. There's been a little bit of regression to 88% of households that have access to potable water. There are still people in South Africa who do not have access to the to RDP standard, which is a standpipe within 200 meters. There's a case in Butterworth that I'm involved with at the moment where people are still relying on a water hole that they have to share with animals. So that's the starting point, right? But if you go to access to convenient potable water, so water that's piped to your home or water that's in a standpipe in your yard, those figures actually, they fall quite dramatically. Then there's unequal access to waterborne sanitation. So something like 12 million people who do not have access to even the RDP standard of a BIP improved toilet. Continued gender disparities in access to water, women not being safe when they have to either go fetch water or when they have to use latrines that are not on their property. The dysfunctionality of our water and our wastewater treatment plants is now well known. The revival of the green drop reports, the blue drop watch reports, and the no drop reports paint a picture of a system that is becoming, it's increasingly in crisis. It's not getting better. The incentive scheme based on these progressive audits is not apparently working. With that dysfunctional water distribution systems and massive non-revenue water losses. In some municipalities, the extent of revenue water loss is more than 50%. If you go to the site of the Auditor General, there are interactive maps which could give you a sense of the extent of non-revenue water loss in some municipalities, which runs into billions of rand. At the same time, rivers and streams buckling under the pollution of sewage, industrial pollution. Turning to water use for economic use, skewed access to water use rights. A few weeks ago, the Department of Water and Sanitation published proposed regulations where there's going to be a very big BEE component. There's a lot of resistance to that, but that just reflects the fact that water use entitlements, because of the entitlement in the Water Act that recognized water use 2 years prior, before it became in effect, the name is sketchy for the moment. Because of that water use entitlements are still quite skewed. Unsustainable extraction of groundwater, top-down centralized decision-making and control, water hoarding. There are already a couple of cases before the Water Tribunal, and people using Section 24G as a loophole to build dams and then after the fact apply for authorization. And then also what I call water infrastructure capture, which is the intentional destruction or manipulation of the water infrastructure network, such that people who've had standpipes or even in their houses water distribution pipes installed don't get the water and then are forced to rely on water vendor solutions provided by those people who are capturing the network. Where do we want to go to? So that's the undesirable state. Where do we want to be moving to? Equally convenient access to potable water for all, equally dignified and convenient access to sanitation, not necessarily waterborne sanitation, minimal non-revenue water, functional water and wastewater treatment plants, responsibly managed pollution, sustainable groundwater extraction, equitable distribution of water use rights, participatory, decentralized, effective governance structures, water and infrastructure stewardship, and clean rivers and streams that support an abundance of biodiversity and providing essential ecosystem services. So, coming now to transformative constitutionalism and transformative environmental constitutionalism. Clare's theory was very particularly focused on the adjudicator's dilemma. So he acknowledged the fact that there were a variety of state institutions and also, the private sector, given the horizontality of the Constitution, that would be involved in this process of constitutional enactment. But his very specific focus was on the adjudicator. And the reason for that was because it is the part of the state machinery where decision-making is, in his words, the most reflective and self-conscious, the most grounded in reasoned argument and justification, and the most constrained and structured by text, rule, and principle. So the adjudicator's dilemma is the dilemma that judges from throughout the ages have faced, where they have this uneasy tension between the constraints imposed by the legal text, but then also that's an uneasy constraint because legal text based in language, it's always indeterminate. And then the freedom of that, and then the desire to give effect to ideological commitments. So in sort of formulating this transformative vision of the undesirable to the desirable, I thought, is this ideological? Is this something that everyone would be able to agree to? Can we have consensus that this is where we want to go? Or what is ideological about this vision? I'm not sure. Possibly there are parts of it that are ideological. But what is definitely ideological is the judge's position on the rule of law and the role that the judiciary plays in a constitutional democracy. And then with that, how one balances state-directed and market mechanisms to achieve a transformative vision. And that's where the bun fight happens, right? So that's where judges can be more or less explicit about how transparent they are on their position on these various things. And this leads to theoretical prescriptions on how judges should view their role, how they should reason with reference to both substance and technique. So Clare's contribution was very significant, and one can see it through the citations of his work. And he just emphasized that judicial decision-making and the resolution of the adjudicator's dilemma in South Africa needed to move us from an authoritarian culture to a new culture of justification. And so he contrasted two models of adjudication. The one he termed a traditional approach to the rule of law and the role of judges, which is that judges needed to check their politics at the courthouse door. Judges being mindful and wary of the counter-majoritarian dilemma, to ensure that they don't overstep the mark of legal argumentation. So they would offer a legal interpretation of the text. And with that, use a repertoire of discursive and argumentative techniques to achieve that. And when I come to the cases a little bit later, my interest is to try and identify these discursive and argumentative techniques, which form parts of a legal culture. Against that traditional view, he contrasted adjudication as being inevitably situated. And it's important to realize that it's a situation in both a political culture as well as a legal culture. And that political culture is changing in dynamic. The political culture we have today is very different to the political culture that we had in 1996. It's arguably a culture where too much emphasis has been placed on the courts to resolve some political issues. The idea of lawfare, Dennis Davis has spoken about this, where courts are burdened with issues that should be resolved through the democratic process. So I think that's an important consideration, but then also a legal culture. And that legal culture is constituted by being part of the community of practice and learning these discursive and argumentative techniques. And it is also performative because it involves working with legal materials. Clare was, at that time, in the late 1990s, struck by the conservatism of South African legal culture. And by legal culture, he meant the professional sensibilities, habits of mind, and intellectual reflexes that framed what judges found to be persuasive. And I just want to emphasize that, Clare was saying that this is socially constructed. It's not given. If we go to the court of Bangladesh, in that they've just done amazing judgments on the rights of a river there, we'd be struck by what they would regard as persuasive. And we don't necessarily see that because we're so embedded in our own legal culture. To describe the conservatism of South African legal culture, he pointed to the cautious traditions of analysis, an approach to legal interpretation that was highly structured, technicist, literal, and rule-bound, and the tendency to deduce specific conclusions from very general abstract premises with fewer intermediate steps of reasoning. And just as a headline sort of finding, my sense is that is very much still in evidence if you look at the very recent cases of the Constitutional Court on water. So I'm just flagging that in case I have to rush the findings at the end. Clare urged judges to be both politically and jurisprudentially more progressive. So politically progressive, in a moment, I'll just present a table where I've kind of summarized what we mean by that. But then also jurisprudentially progressive in moving away from some of these cautious traditions of legal analysis and adopting other ways of framing persuasiveness. But then there's like a little throwaway line in his article that I think is very significant. And he says the political context can also influence what counts as a transformative stance. And astute judges, although they might not overtly say it, might, for example, adopt quite cautious traditions of legal analysis, aware of their place in the system to push the more democratically accountable parts of the state machinery to do what they're supposed to do. Okay, now comes to the work of my colleague, much admired colleague, Melanie Murcott. And Melanie has done very good work to take transformative constitutionalism and apply it in the environmental sphere. So her work joins the concept of environmental constitutionalism and transformative constitutionalism. Environmental constitutionalism is the recognition that the environment is a proper subject for protection in constitutions and for vindication by constitutional courts worldwide. It goes back to the 1970s when states started and sub-states, provincial and state legislatures started putting these provisions in the constitution. So there's a whole body of literature on environmental constitutionalism. And I think Melanie's contribution is that she has made a very specific linkage between transformative constitutionalism and transformative environmental constitutionalism, given the South African context, which is actually a microcosm of the world. And her work places a marked emphasis, and I think more so than other theories of environmental constitution, on social justice and the intersection of social and environmental, climate, socioeconomic injustices. So she has already done the work of pointing out how judicial reasoning in many environmental cases exhibits many of the problematic features, the problematic conservative features already highlighted by Claire. Some of these features include overlooking the social, either if you take environmental cases, either overlooking the social drivers of injustice, or if you're taking social cases, overlooking the ecological drivers of that social injustice. Over-proceduralization, a failure to develop the substantive content of the rights, and failure to link the environmental rights with other rights. And she calls on judges to adopt a socio-ecological systems perspective that recognizes the intersecting social, environmental, recognizes these intersecting injustices. So this, of course, immediately makes me think of resilience theory and social ecological systems and adaptive management and adaptive governance. And I think there's still work to be done in thinking through how a theory of transformative constitutionalism uses the insights of some of that body of theory. There's also, I don't think, the place yet of animal and nature rights, how that fits with the theory of transformative environmental constitution, but for that, it doesn't need to concern us. And then also how radical this is supposed to be and how much a theory of transformative environmental constitutionalism could drive redistribution. And then also thinking through, and this is something, there's always going to be trade-offs, the transparency of trade-offs. So taking those two theories together, this is back to my first question. How do we say that something is transformative or not? And so going from transformative constitutionalism, that a judgment is transformative if it advances substantive equality, particularly in its material aspects, actual access to water or housing, that it recognizes distributional justice issues. It promotes procedural justice, including in decision-making, recognition of equal worth and dignity, a recognition justice. What Melanie's theory adds to that is this cognizing and framing a matter in terms of the intersection between these various types of injustices, adopting a systems approach to understand the distribution of burdens and benefits, a commitment to dismantling the system of racialized capitalism, expanding the community to future generations, and recognizing nature and interspecies justice. Those ones which are starred are the ones that I feel could still need some work, some elaboration. Taking into account what is jurisprudentially progressive, these would be alternative discursive and argumentative techniques that could be added together with the traditional techniques to make a judgment both politically but also jurisprudentially progressive. So explicitly acknowledging the politics of adjudication, substantive and purposive legal reasoning, not limited to legal authority, but also invoking these moral and economic considerations, value-laden decision-making, the courage to act mero motu, to bring in values and legal authority not necessarily raised by the parties, adopting a contextual approach, avoiding the pitfalls of formalism and so on. Transformative environmental constitutionalism plus adds to that socio-ecological systems perspective and the rich principled basis of environmental law, interdependency of rights, and then being transparent about trade-offs. So that essentially was, and I spent like quite a few weeks just thinking this through and organizing it in my mind. That is my frame of reference when I'm coming to the water cases. Before I introduce them, I just want to spend a moment on the polycentricity of water disputes. And this is really, these are just two diagrams, and they come from the wonderful Johanri Wright, who's a postdoc that used to work with NL, and now she's working with me on a project that I have with the Human Rights Commission on water justice. And Johanri's amazing, but she developed these diagrams for a report that we did, and it just shows, you know, it's just bringing home that when you open that water from the tap, it is the end of a pipeline that is very long. And it is an end of a pipeline that involves a natural, an ecological gift, a natural resource. But that natural resource needs to be translated by, you know, treatment processes, infrastructure systems, which firstly focus on treating the raw water, storing the water, transporting it in bulk to our homes. I mean, I'm sure you all know this, but it's just good to kind of have it in your face that we are dealing with systems within systems, systems of treatment, of storage, of transport, of distribution, and many, many stakeholders. This is another diagram that Johanri developed. If you just take the infrastructure components, distinguishing between the responsibilities, the statutory responsibilities for building infrastructure, maintaining infrastructure, and then actually pushing water through pipes, you start getting a very complex picture. And this is just the state functionaries. This is not, you know, it doesn't even bring in water users, the people who are, you know, accessing that network in a different way. It doesn't bring in the complexities of the biophysical systems that water is embedded in as well. So, you know, I just to underline the point that potable water is a polycentric issue that is going to involve many stakeholders. And it is also a very clear example of what I've written about previously, of it's a case of its development in environments. You have to have the infrastructure, otherwise, you know, in terms of the current technology that we have, you're not going to have water in your taps. So it's about looking at the legacy that infrastructure provides and the relationship to that infrastructure that's significant as well. Okay, I am aware that I'm running out of already almost half past, so I'm going to now introduce the cases. So Mazibuko probably needs very little introduction. This is a case that was decided in the late 2000s, and it dealt with the constitutionality and the legality of the City of Johannesburg's free basic water policy and the installation of prepaid meters in Piri, which was a very poor part of Soweto. It was a unanimous decision delivered by Cato Reagan. And in this case, the Constitutional Courts, it was regarded as one of the big sort of test cases on socio-economic rights. But the courts declined the invitation to quantify what sufficient water means in Section 27(1)(b). The parties had specifically said they're not aiming for a minimum core, but they wanted a quantification. The court basically said this is just like minimum core, and they refused to do it. So they declined the invitation to say that sufficient water in the Constitution means 50 litres per person per day. And they also affirmed the reasonableness of the City of Johannesburg's free basic water policy and the lawfulness of prepaid meter installation, which was regarded as a massive blow at the time. The case itself has been described as deeply anti-transformative. The bulk, the consensus of scholarly opinion and is that it had a very chilling effect on socio-economic rights litigation, that it was not pro-poor at all, and that it really put a damper on using the socio-economic rights in the Constitution. The second case, but I assume that Mazibuko is well known to the audience that is here today. The second case was decided in 2021, and this was a case brought by the Minister of Water and Sanitation versus a private water service provider called Sembcorp Siza, who had been contracted by Ilembe municipality to provide water services. So the case centered on the legality using the rationality standard of Mgeni Water's decision to recommend a differential tariff increase of 41.4% for the bulk water that it supplied to Sembcorp Siza. At the same time, the tariff increase for municipalities was somewhere in the region of 8%. So it was a massively, greater tariff increase for Sembcorp Siza. And then they had submitted that proposed tariff increase to the minister for approval. And then one of the issues in the case was whether the minister had the power to approve tariffs. The majority decision, which was delivered by Justice Jafta and Justice Victor, upheld the rationality of Ngani's proposed tariff and held that the minister had no power to approve the tariff decision. And then there was a minority decision written by Justice Madlanga, in which Justice Theron concurred, which dismissed the appeal on the basis that Mgeni had not actually taken a decision to approve the tariff increase. So that was Sembcorp Siza. And then the third case, which was handed down in March this year, is the case of Lotter in Ovid. Was about 3 cases that were all joined around the same issue. And it concerned whether the National Water Act, allowed for the temporary and permanent trade in water use entitlements. This matter had gone through the High Court and the Supreme Court of Appeal. In the High Court, the minister had been successful. Then in the Supreme Court of Appeal, said that water trade is allowed, and we'll get into why that's a political and a legacy issue when we look at inequalities. And in the constitutional courts, the unanimous decision was that the Water Act does allow for trade in water use entitlements. This was essentially a trade that is based on 2 provisions in the Water Act, Section 25 and Section 41, which allow an existing holder of a water use entitlement to surrender part of that entitlement for another third party to submit a license application, and then a private contract between the two for the sale of that water use entitlement. And the cases involved, the figures were very large. It ranged from, just about 1.9 million to 15 million rand for the trade in these water use entitlements, which the Department of Water and Sanitation had problems with from 2018. And so in Lotter, the Constitutional Court held that the Water Act does not clearly prescribe and can be interpreted as accommodating trade in water use entitlements. So as a very quick summary view, Mazibuko was regarded as politically not progressive, as well as jurisprudentially conservative. Sembcorp Siza can be, at face value, politically progressive, because we are making sure that private service providers don't make a buck off public entities like Mgeni, and we'll get into the reasons for that. So politically progressive, but also jurisprudentially conservative. And then this Lotter case, particularly politically non-progressive, as well as very jurisprudentially conservative. So just as a sort of overarching evaluation, with the frame I was using, those are kind of the conclusions that I could come to. And I just want to turn to the themes that I mentioned at the start of the presentation. Sorry, Angela, I see you. Do you want to stop me? I hope not.
No, you can continue.
Okay, great. All right, so how did these 3 courts, which are separated, Mazibuko in the late 2000s, and then Lotter 2021, Sembcorp Siza 2021, Lotter 2023. What can we see any trends, patterns in how they approach a theme like inequality or a theme like water as a commodity. And what are, and this is the most interesting part for me, what are the argumentative and discursive techniques that they are using to grapple with the dilemma that they're faced with? So if you start with inequality, Mazibuko, the very first paragraph of Mazibuko acknowledges the historically grossly unequal access to water and the deep inequality that remained with regard to access to potable water. But that still didn't stop them from dismissing all of the applicants' equality-related arguments. And those arguments had been raised in relation to the universal allocation of free basic water. The applicants had said it's not fair that both rich and poor should be able to get free basic water. And then also an equality argument in relation to the installation of prepaid meters. And the argument there was that the Piri, as a marginalized Black neighborhood, had been unfairly discriminated against, because those same prepaid meters were not being imposed on white neighborhoods, and the residents of Piri did not have the option of a credit meter. But those arguments were essentially dismissed. So when you read the judgment, you get a sense of what that was driven by. And this is not necessarily, and it can be more or less explicitly stated. And I think Mazibuko, as much as it has been maligned, is probably the high water mark for making these things explicit. Because from the fairly lengthy judgment, you're able to discern that the reason the courts were able to dismiss these equality-related arguments were essentially threefold. Firstly, there was sympathy for the scale and difficulty of the administrative and financial task of providing and accounting for potable water to this growing city of 3.2 million people. Secondly, there were multiple comparisons made throughout the judgments, and it gives the effect to something Ndozi has written about, which is this relative deprivation, which is something that has, we've moved on from 1996, and now we have access to water, but there's still the best access to water, which is potable water in your home and waterborne sanitation, is still not enjoyed by the majority of the population. So the court used these multiple comparisons to make it look like the people in Piri were not actually that bad off. So they were compared to other Black areas like Ivory Park, Alexandra and Orange Farm, and also other people in Johannesburg who didn't have any access to water whatsoever. So that was the second driver, I think, of their position. And then thirdly, the scale of the unaccounted for water problem in Piri, which was something like the city of Johannesburg supplied 25% of the water and they got 1% of the revenue. So those three things. What were the techniques that they used to be able to come to this position of the position on inequality? So two key things: the resort to the rational connection to a legitimate government purpose, and you can see there that the purpose, finding the purpose, that the purpose of the law was to eradicate these severe water losses, was a legitimate government purpose, enabled them to essentially dismiss these equality arguments. That was the technique. And then acceptance of the reality of differential treatment. And that's just, I thought, one of the key quotes from the decision. So issues, the dismissal, the point of view, and then the technique: rational connection to a legitimate government purpose and differential treatment. If you go to Siza, equality arguments were also made. In this case, Siza argued that it was being unfairly discriminated against, and that as a private entity, in both the High Court and the Supreme Court of Appeal, the Constitutional Court, the courts held that this was an irrelevant consideration because Siza had essentially stepped into Ilembe's shoes. But the Constitutional Court disagreed. And so they wanted to foreground the fact that Siza was a private entity. And their position was driven by different kind of points of view. So firstly, that Umgeni was making a loss on its north coastline. And then, although, I put question marks here because the court doesn't actually make this very explicit. So going against one of the key tenets of transformative constitutionalism, which is about being transparent about the political nature of the decision. So the importance of eliminating cross-subsidization, distastefulness of a private entity making a profit while the bulk supply suffered loss, and then possibly class considerations, because we're talking here of a municipality, Belito, Shockers Rock, and Salt Rock, which is not necessarily upper middle, but it's middle-class suburbs. Again, you see the techniques involved. So this judgment relies very narrowly on a rationality standard. So it just accepted, really, that there was a rational connection between the tariff increase and the elimination of the cross-subsidy, and that eliminating the cross-subsidy was a legitimate government purpose and had been established. They placed particular emphasis on this narrow rationality standard, and I think that that last sentence is quite significant. Rationality is the lowest threshold for the exercise of power. If a rational connection is present, a review challenge must fail, regardless of the cogency of reasons furnished for the decision in question. And they actually criticized the decision in the Supreme Court of Appeal and the High Court, saying that the courts erred by looking at reasonableness, because they were not just interested in whether there was a rational connection between eliminating the cross-subsidy and eliminating cross-subsidization and the tariff. They wanted to see, would this be an effective, was this, if you looked at what would this 10 million saving really mean in Umgeni's total budget? They said the court erred in that. You must just look, is there a legitimate government purpose? Is there a rational connection? Also highlight differential treatment and point to its necessity and importance and the need for differential treatment in governing a modern country. And what I found really interesting was that whereas Mazibuko was prepared to go on to sort of think through, there was an attempt to think through unfair discrimination using the Hodgson test. In Sembcorp, you don't even go that far. Just by virtue of the fact that you need to differentiate between people in a modern state, the rationality test could be applied positively. It was then unnecessary for the court to consider whether the differentiation in question amounted to unfair discrimination, which I think is problematic, because one of the points that was raised in the High Court and Supreme Court of Appeal was that this increase would be passed on to consumers, and secondly, that Ilembe was the guarantor of Sembcorp's debt. So the courts didn't even go that far to think through, would there be some harm? What are the systemic consequences of just upholding this very narrow rationality standard? And then finally, Lotter. And Angela, I'm going to, although I really regret having to do it because the next part is really important about water as a commodity, I will just finish this slide and then go to my conclusions. Lotter is an equality argument was also raised. You can see there the minister's argument around Section 25 water entitlements by allowing these water use entitlements, which are largely in the hands of very wealthy farmers. You will create an enclave in which a scarce natural resource is traded, and you will perpetuate the imbalances of the past, and this is against the right to equality. Court hardly dealt with that. Well, it did deal with that argument, but in a very interesting way. But the invitation to engage with either a rights review or a reasonableness review was there. The court didn't do that. And instead, its point of view, which was that water trading was allowed, I think was driven firstly by two kind of ideological commitments, which are not explicit. The first was that the department itself had allowed water trading to happen in this way up until 2018. And secondly, and this is quite remarkable part of the judgment, where the court speaks about a marked difference between the legal constraints that are imposed on private persons and organs of state. And then they follow the lead of the Supreme Court of Appeal in citing a 1995 English case, which says that for private persons, the law For private persons, the law is that you may do anything you choose, which the law does not prohibit. But for public bodies, the rule is that any action to be taken must be justified, which I find remarkable because you have absolutely no reference at all to that the Constitution governs public and private power. It is horizontal in its conception, and this is quite remarkable statement. If you look at the techniques involved, firstly, very conservative and traditional rules of statutory interpretation being invoked, ordinary grammatical meaning, arguments from the absurdity, the textual content, erasure. I think that by asserting this private realm of interaction, the court makes no effort to recognize the fact that not all private parties are on the same footing. And then, very curious, at the end of the judgment, something called an epilogue, titled epilogue, where the judge says, Madlanga says he's not dismissive of the state's concerns, that water remains largely in the hands of advantaged white farmers, and that this is the reality, so he acknowledges it, but then bluntly concludes that, unfortunately, the Act does not admit of that redress. So some similarity in the techniques involved, but I think also like a bit of a pulling back from, we criticized reasonableness review in Mazibuko, but now we are going back to a far differential technique, which is just this narrow rationality standard and very traditional rules of statutory interpretation. So I'm aware I need to stop soon. I'm just going to give you a taste of the social commodity arguments. Essentially, Mazibuko has been castigated on the basis that it contributed to the commodification of water, and that it was, put into a neoliberal, immediately associated with a neoliberal capitalist paradigm. These are the techniques that Melanie has, I think, very, very eloquently outlined in a 2015 article and in her book and in her thesis. I don't really agree. I don't think that I don't think it's appropriate and correct to describe potable water as an ecological gift. If you go down to the Yukske River or any river in Gauteng River and you take that ecological gift, you're going to get very sick. We cannot have potable water without infrastructure. If you want to say that water is not a commodity, you actually erase all that labor involved in bringing it to your mouth. And so I think that Mazibuko was, I think we can distinguish between different ideas of water as a commodity, and it is not bad to talk about water as a social commodity because you need some cost recovery. And this is why our municipalities are in such a state of dysfunction, because what is the central fault line? And this is something that Libugard has already outlined. The central fault line is decentralized and underfunded local government, and how those grants and the equitable share work and the kinds of standards that they're held to. And the Treasury actually has a whole list of investments that municipalities are supposed to be making in their infrastructure, how much they're supposed to be getting from user fees for maintenance, but then also upgrading and maintenance. And that is just a pipe dream in our reality, where more than half of the residents of the city are very poor and cannot pay for those services. So that's the central fault line. Mazibuko was ill-suited to address that fault line. And so it's a little bit unfair to criticize the commodification of water. Sembcorp and Lotter, I think, are a different story. In Sembcorp, we're dealing with the elimination of cross-subsidization, very little reasoning about it. But where will that go? Where will a precedent about cross-subsidization being a legitimate government purpose go? To what other kinds of contexts could it be applied? I don't think any thought was put into that. And then very problematic commodification of water. And I think this is a real problem. That in Lotter, essentially, the court was quite comfortable with the fact that money had changed hands. And they justify it with reference to property relations. There's paragraph 35. The reality is that a farm with water use rights is worth more than the same farm without water use rights. But where does that go? What are the systemic implications? Not at all considered. I think if you're going to have a problem with water as a commodity, then Lotter is your case to jump onto. Okay, transformative adjudication, very little jurisprudential progressiveness. So where does this all lead us? I had approached these cases quite hopefully, but my sense is that we have lost some of the spirit and some of the urgency around this value-laden decision-making and adjudication, and the importance of both political and jurisprudential progressiveness. And there's almost been, like, Mazibuko was criticized, but I think there's been it's regressed since then. So these are just some ideas for how we can start infusing these judgments and infusing our judicial system and our judiciary system with this vision. Invited amicus briefs, judicial awareness and education, training the law clerks, and then also rewriting projects, judicial rewriting projects. So that's it, Angela. I'm sorry that I ran a little bit over time, but we do still have a little bit of time for questions.
It's all right. Thank you so much. I really can't wait to read your paper. That was such a thought-provoking presentation, especially just on rethinking the role of the courts and what we mean by transformative constitutionalism. I'm going to open then the floor for some questions. People can raise their hand or type in the chat. There were comments from Melanie. Melanie, do you want to ask a question or just repeat your comments?
Sure, I can just say thank you to Tracy for such a wonderful presentation. I agree, vital to critique these cases, and we do seem to have lost a bit of the energy in the water space, so it's wonderful that you're breathing life back into the critique in that space. And sort of just two points I would say is that I think the idea of environmental justice was kind of missing in all three cases, and could have, as a principle, as a substantive value-laden principle, could have perhaps informed interpretation of water law as it's done in the context of pollution, not necessarily explicitly, but at least implicitly in some ways, in holding polluters accountable. And then the comments in the thing are about the very specific context in which I raised the idea of the critique of commodification, but that I think we can talk about offline. And then just the last point on socio-ecological systems thinking is something I would encourage everyone to give a bit of thought to. And as much as I agree that there are trade-offs and we must be open and transparent about those, one of the benefits, I think, of socio-ecological systems thinking is that it tries to take us away from binary thinking and to look for synergistic solutions. So to resist trade-offs where possible by resisting false binaries. So I hope that's a helpful comment and question.
Thank you, Melanie. Do you want to respond to that, Tracy?
Yeah, absolutely. As I said at the beginning, when you start working with these theoretical frames, you can see so much in the cases, and then it's like, what do you focus on? So the ways in which environmental law principles and environmental rights could have taken those judgments down a different track. I mean, that's a PhD in its own. And then yes, Melanie's correct. It's not just there is the element of prepaid water meters, which has a commercial and a capitalist framing, but I also, I wanted more information about that. It's very relevant and important, and she's correct that is an added commodification part of water services, and it's very real now. I mean, I heard that Tshwane is planning to roll out prepaid meters.
Mm-hmm.
Yeah. So who benefits? How does that link with procurement? How does that link, where the profit's going? That's a really important question.
Yeah. We have a few more questions in the chat, it seems. So one is from Dr. John-Claude Ashakem, who asks, within the framework of the rights of nature, how do you see the use and implementation of transformative environmental constitutionalism by a court as a tool to drive the protection of ecosystem structures like water? And there's also a question from Khanmari. Would you like me to read that one too?
Yes, please. I can't see the chat.
All right, so Khanmari says she can't unmute. So she says, I am contemplating the Concord decision in the Lotter case. Fascinating, especially from your perspective. I agree that the trade of water use licenses may not or are not political transformative, especially due to the extreme amounts of money asked for it. I do, however, think one should take one step back to keep in mind that the initial water use application by the seller or trader of the water right had to go through due process of public participation, meeting the objective set out in Section 2 of the National Water Act. Before the water use license had been allocated, that should have been the transformative exercise in the first instance. Should the redress exercise not rather take place earlier, i.e., during the application process rather than the trading phase? But then this was not the focus of the case.
Yes. Okay. So I'm going to respond to that, and I've also seen Anel's. Now I realized I had to open the chat. So I've also seen Anel's comment.
Yes.
So I'm going to speak to all three.
Okay.
So I think in Melanie's thesis somewhere, it's a paragraph, but I thought there's just so much in there. She talks about the different roles that judges can play, that they have a storytelling role, that they have this role to be, the absolute inspiration, like our highest aspirations, to articulate that. And I have an LLM student at the moment who's doing a project on the rights to water, water and nature rights, and she's been looking at some of these other cases in India and where they've recognized the rights of rivers. And reading her work and reading these judgments, it's like your heart sings and jumps, so absolutely. And this is, it's in these, where the judges have to take the lead. They have to take the lead in rights of nature. So I think it's really important and really critical that it's not, and I hear your decision about binaries, Melanie, but not just one trade-off, but trade-offs. Something's got to give. Something's got to give if you're not going to have, a river being destroyed. And that's not necessarily, for sure, it's the practices of the rich, but it's also sometimes the practices of the poor. So you need to be open to look systematically through, and be able to see where those burdens and benefits are landing. Not easy, it's hard, but yeah, I definitely see that there's space to further develop the theory of transformative environmental constitution and to accommodate rights of nature. On your point, Khanmari, it's interesting to me that the constitutional courts, because the Supreme Court of Appeal made those points, and they also made the point that this was beneficial use. If somebody is not using the water use entitlement, then somebody else should be using it. It's actually in line with the objectives of the Water Act, and that the minister should be deciding this. That's the point where it should be decided. But it was just like such a bare bones judgment. They didn't bring that through. But I think you're right. I think that it can occur at that previous point. But then at least they should have said that. They didn't even say that. And then Anel's point about, have the courts not perhaps lost faith in the executive over time? Can we blame the triflitica and resultant judicial deference for part of the judicial hesitancy in our recent water law judgments? And I thought about that, right? I can imagine the constitutional court judges sitting in their chambers going, yet again, we have a situation where, you have this flaky department, so unstable over the years, charges of corruption and maladministration, almost going bankrupt, and they haven't put their house in order. They haven't actually made it clear in the legislation that water trading is allowed. And now we are being required to take the lead here. And you can also almost imagine them saying, and this is where I made that point about clear that transformativeness is linked to the political context of the time. We're putting back. We're just putting back. We're doing the minimalist judgment, and we're putting the ball back into their court. And lo and behold, a few months after this judgment, you have regulations on BEE, and you have to take the bull by the horns. So I think I hear you, and I think it underscores the point that you can't evaluate what is transformative without taking into account the political context as well as the legal cultural context.
Thank you. We have a question as well from Nina Rhoda.
Hi, Tracy and
Hi,
everyone.
Nino.
So it's quite an interesting presentation, and it's interesting particularly to see section transformative constitutionalism and section 27 that you're looking at, and more than that. And my PhD is on looking transformative constitutional around constitutionalism around section 33, just administrative action and public procurement provision. But my question for your presentation will be, as I understood, it's hard to filter through what you shared now in one webinar, because I'm sure you spent a lot of time to research all those things. But just as I understood, you shared 3 cases that were filtered against the theory that you were coming up like politically progressive, jurisprudentially progressive, and the judges that make decisions in those 3 cases that you were analyzed. So is there any positive case out there that you kind of you like it and you say, okay, this particular case politically, or part of the case is politically progressive, and realizes, and jurisprudentially progressive and realizes transformative adjudication, and that's what we're looking for. I like this case. Is there any such case that you come up across with?
Yes. So, Nina, as you will well know from our work together, we have more than 80 water-related cases, and we haven't, I haven't gone through all of those 80 cases. I'm sure there's some judgment out there in the High Courts or Supreme Court of Appeal maybe that will have an example, but my interest here was to focus on the Apex Court. But my next one, my target is going to be the Africa case, which I'm sure is also not going to be politically and jurisprudentially progressive. But yes, I'm sure those cases are out there. Let's find them.
Right, thank you. Unfortunately, I have to close the questions now, but thank you so much for interacting and asking these insightful questions. And thank you again, Professor Tracy, for your presentation. This was really so insightful. And I look forward to reading your paper and maybe emailing you my questions that I had.
Great.
Just then, before we close, I just want to remind everyone that the Environmental Law Association is hosting their annual national and student conferences. So the conference is taking place between the 13th and 14th of October at Nelson Mandela University, and the theme is on new frontiers in climate law and governance. Tomorrow is the last day to submit an abstract, so I would like to invite everyone to please submit an abstract or to consider attending and even to joining the Environmental Law Association as a member. I've sent the link in the chat to everyone. And yeah, we don't yet have abstracts on water in the context of climate change. So I'm inviting anyone who's interested here today to do so. But thank you again from my side. We will release the recording of this webinar on our YouTube page. Thank you again, Professor Humby, for joining us today, and everyone else. I really appreciate it.
Thank you so much. It was a pleasure.
Thank you. Bye-bye.
Thank you. Bye.